The Trump Mar-a-Lago search warrant affidavit finally revealed, sort of. A lot of redactions, but there's still stuff that we can tease out of this, and so we are going to do that. We're going to approach this by doing a quick read of the affidavit itself. I've got that pulled up. We are going to mark it up in usual fashion. You can see it is 38 pages long, but because most of it is redacted, we're going to be able to go through it relatively quickly. But this is a once-in-a-lifetime type of document. Okay, we don't ever see affidavits signed by special agents to go and raid former presidents in this country. Of course, maybe it's going to start that we have a lot more of this now that the floodgates have been opened. But this is a historic thing, right? This is going to go in law school books all around the country. People are going to be reading about this case, just like we sort of read about Bush versus Gore. Right? It's a monumental thing that's happening. And so I want to make sure we pause on that for a minute. But as you can see, it's 38 pages. And so after our quick read through, we're going to take a look at it in a little bit closer detail. We're going to look at the probable cause paragraph. Okay. I clipped out the specific paragraphs and we're going to unpack them. We're going to look at the U.S. Code provision. You can see we've got 3 sections under 18 U.S. Code 793, 1519, 2071. We're going to look at all those. A lot of this is predicated on Barack Obama's 2009 executive order, so we'll refresh our recollection there. We'll really tease out the timeline before we get into some of the major problems with everything that is in here, everything I should say that is not in here, what is missing, and what may have been persuasive to the judge had he known about it before he signed off on the warrant that authorized the invasion. So, as I said, we're going to start with a quick read through, and as you'll see, we are going to give this some attention, but it'll happen relatively quickly. We'll be able to fly through this. You see, it is the same docket that we've been following for quite some time now on this saga, filed under seal, and this was the sort of supporting document that went under the search warrant affidavit and the search warrant inventory and the application, all of that, what was sort of requested. This was the explanation for all of that, and we never saw this up until today. A lot of fighting over this. The DOJ did not want this to become public. This is drafted by a special agent. He says, I am first duly sworn and hereby depose, I state as follows. This is our application for a warrant to search and seize, of course, Trump's residence. The government, in paragraph 1, is conducting a criminal investigation concerning the improper removal and storage of classified information in unauthorized spaces, as well as the unlawful concealment or removal of government records. The investigation began as a result of a referral the United States National Archives sent to the U.S. DOJ on February 9th, 2022. We have that in our timeline. The NARA referral stated that on January 18, 2022, this year, in accordance with the Presidential Records Act, NARA received from the office of former President Trump, hereinafter F. POTUS, via representatives, 15 boxes of records, hereinafter the 15 boxes. The 15 boxes, which had been transported from Trump's property in Mar-a-Lago, is a residence and a club known as Mar-a-Lago. And they say here that we describe in attachment A that those boxes were reported by NARA to contain, among other things, highly classified documents intermingled with other records. So NARA goes back January 18th. They have all of these conversations. NARA on the 18th got boxes, 15 of them, and there was stuff in there. And that sort of prompted the inquiry. Oh my goodness, look at these boxes. What's in here? So they sent a referral over to the DOJ earlier in the year. So the DOJ now, right, which is the prosecuting entity of the United States, they are working with the FBI. They say, all right, now FBI says, okay, after an initial review of the NARA referral, why this came over in the first place, the FBI opened a criminal investigation to, among other things, determine how the documents with classification markings and records were removed from the White House. Now, put a pin in that. We're going to come back to that. Open an investigation into how. All right, so like physical boxes, like moving trucks, like people physically moving boxes out of the White House somewhere else to Mar-a-Lago, or any other authorized locations of classified materials and how they came to be stored on the premises. And I mean this like specifically, like a U-Haul came and 3 guys came out with jump chutes and boxes, and they put the boxes on the U-Haul and took them to Mar-a-Lago, took them off the U-Haul and put them in the location, right? That's specific. They're saying to determine whether the storage locations at the premises were authorized locations for the storage of the classified info, and to determine whether any classified documents or records may have been stored in an unauthorized locations at Mar-a-Lago or other unknown locations, and whether they remain at any such locations, and to identify any persons who may have removed or retained classified information without authorization in an unauthorized space. All right, so basically, this is the FBI opening the floodgates. They say, okay, this NARA referral came over, and we had to ask ourselves all of those questions. That big list of, you see every single one of these semicolons. Determine whether and, analyze this and identify. They're doing all of that as part of their investigation, which basically means like it's a full onslaught of surveillance of Trump at Mar-a-Lago. Paragraph 3, we get a little redaction here. Get ready for it. Paragraph 3 says, number 3, the FBI's investigation, now that we have to ask ourselves all of those questions, has established that documents bearing classification markings versus, markings, my presumption would be that you can have a classified document that is declassified that would still have the original classification markings on it. Now, if you can have a declassification over the classification marking, does that override the original underlying classification marking? Right. So that's the first question I would be asking. They say it bears classification markings which appear to contain NDI information, national defense information, were among the materials contained in the 15 boxes that were stored on the premises in an unauthorized location. Now, I'm going to guess that the rest of this redacted paragraph, or these couple sentences, is talking about that unauthorized location. They were stored at the premises in an unauthorized location. One witness named so-and-so, a janitor at Mar-a-Lago, he reported that when he was sweeping the floors, he saw Donald Trump break the clavicle of a Secret Service agent before he went into the closet and read the documents over a cup of tea. So they say further, there is probable cause to believe that additional documents that contain classified NDI or that are presidential records subject to record retention requirements currently remain at the premises. There is also probable cause to believe that evidence of obstruction will be found at the premises. And so we're going to unpack that in a minute. As I said, let's read through this quickly and then we'll spend another round going through this. Paragraph 4 says, I'm a special agent with the FBI assigned to Washington Field Office at so-and-so and so-and-so. During this time, I have received training at the FBI Academy located at Quantico, Virginia, specific to counterintelligence and espionage investigations, and I'm very good at what I do, and so-and-so. He says, based on my training and experience, I am familiar with efforts to unlawfully collect, retain, and disseminate sensitive government information, including NDI. And this FBI agent writes, in paragraph 5, I now make this affidavit in support of an application under the rules of criminal procedure to go raid Mar-a-Lago based upon the following facts. And there is probable cause, right? We're going to spend some serious time on this one paragraph, saying there is probable cause to believe that the locations to be searched at Mar-a-Lago contain evidence, contrabands, fruits of crime, or other items illegally possessed in violation of U.S. Code, these 3 separate sections. Then we get to the source of the evidence. FBI agent writes, the facts set forth in this affidavit are based on my personal knowledge obtained during my participation in this investigation, and information obtained from the FBI and U.S. government personnel. Because this affidavit is submitted for the limited purpose of establishing probable cause in support of the application for a search warrant, it does not set forth each and every fact that I or others have learned. They talk about some statutory authority and where they get the ability to do this. First of all, they take us over to 18 U.S. Code 793E, and we'll take a look at this in a little bit more detail and context. But this is the law, right? This is the actual provision of the law that they say might be at violation here, might be at issue. Whoever having unauthorized possession or control over any document or information that has national defense information that could be used to injure the United States, and that the possessor, the person who has possession of the document, has reason to believe that could be used in that harm, shall be imprisoned for 10 years if they are in possession of those documents. right? Here's another one. Under Order 13526, this is the order that came out from Barack Obama. He published this order back in 2009. You see him here giving us this interesting face. And this is more about what the order actually says. Very briefly, President Executive Order 13526. The order prescribes a uniform system for classifying, safeguarding, and declassifying national security information. Stuff related to transnational terrorism, signed by Barack Obama. The affidavit says that it gives us some rules and how things are classified, and saying that this is what prohibits unauthorized disclosure that could cause national security damage. They now give us a little bit of details, right? This is all sort of definitions. It's almost like reading a dictionary. So they're giving us this layering of authority. They say, okay, U.S. Code 793 says this, executive order that was issued by Barack Obama interprets the law accordingly, and thereby we have the following definitions. Information may be classified as following. It could be confidential. And if it is classified, if we put that document in that bucket, here's what it says, and here's how we define it. Confidential is information that if unauthorized, if it's released, it could cause serious damage. That's why it's got to be safeguarded. Secret must also be properly safeguarded. And they say unauthorized disclosure that might result in exceptionally grave damage to national security is going to be top secret, right? So all the different elements. SCI means sensitive compartmented information, classified information about the analytical process and control systems. Special intelligence, another definition in our dictionary, is an SCI control system designed to protect technical and intelligence information derived from the monitoring of foreign communication and signals and so on. And Human Control System, HCS, is an SCI control system designed to protect intelligence derived from clandestine human sources, commonly referred to as human intelligence. All right, and I see a lot of people hyperventilating over all of these acronyms. Oh my goodness, HCS and FISA and HUMINT and SISC, all over Twitter. These people are melting down over this stuff. And it sounds really, important. A lot of definitions on there and a lot of things. We'll have to see what's in there, won't we? Foreign Intelligence Surveillance Act, they give us another definition, is a dissemination control designed to protect intelligence information derived from the FISA court. Do you know that we talked a lot about the FISA court, didn't we? There was some FISA court conversation when we were talking about illegal spying on Donald Trump's campaign and some other interesting things. You certainly remember that. When they got illegal access to warrants and certain things. Now, classified information, they say, may be marked as not releasable to foreign nationals. And they give us another classification of originator controlled. This marking indicates saying that dissemination beyond pre-approved entity requires originator approval. And we get more definitions now. So they're just telling us, right? There's no new information here. You can go on the internet and just find out what all this crap means. And they say classified information of any designation may only be shared with persons determined by an appropriate U.S. government official to be eligible for access and who possess, quote, a need to know. Among other requirements, it's really nice. This is a really great book report that they've written here for us. Among other requirements, in order for a person to obtain a security clearance allowing that person access to classified U.S. government info, that person is required to and must agree to properly protect classified information by not disclosing the information to persons not entitled to receive it, by not unlawfully removing classified information from authorized storage facilities and not storing it in unauthorized locations, okay? What they're telling us is if you take a library book out of our government library, you got to store it appropriately, all right? You can't put it in someplace else, and you got to make sure that you actually keep the book cover on it. You can't take the book cover off. Don't you even think about using it as a coaster. None of these things. And so they're giving us the detailed manual about when you should return your library book and who's in charge of all this crap. What they're forgetting, right, is that Donald Trump sort of owns the library and he has the discretion to make decisions on many of these books. He says, I built this whole library. And I have the authority to say, that's my book now. That is declassified now. That is no longer in the same category because I ran the library and I was in charge of all of those things. So they write, and they're sort of responding differently to that, right? They're responding saying, let me explain to you why that doesn't apply. If a person is not eligible to receive classified information may not be disclosed to that person. And so we're having conversations about a lot of this classified information, but a big missing component to this is what if Trump had declassified this stuff or said that this is not classified? We're going to talk about that in a minute. In order for a foreign government to receive access to classified information, the originating U.S. agency must determine that release is appropriate. Under that executive order that Barack Obama entered, this includes all sorts of computer systems and classified information storage facilities. And then we have what is called the CFRs. Okay, the CFRs are what are called Code of Federal Regulations. And so what ends up happening in the United States is we have the legislature codifies law, right? So they'll actually write the U.S. code like this. And then they'll write regulations that interpret the code. And so that's what we're looking at here. Parts 2001, 2003, they regulate the handling of the classified information. And these are the three statutes that we can take a closer look at. We'll see sort of how time goes, but here's what they're telling us. These are the three sections that made up the probable cause basis paragraph. And they've got several provisions where they talk about intent to take and carry it away and intent to unlawfully conceal, willfully, unlawfully conceals, right? We're going to come back to this intent point in a minute. But knowingly alters or conceals or covers up any tangible object with the intent to obstruct or influence the investigation. Right? All of those are very important sort of foundational pieces that they're predicating the charges upon. They give us some presidential rules, Presidential Records Act, and we're going to come back to all of this. But this is just copy and pasted directly out of the U.S. Code, right? That's all this is. So this isn't anything new. They're just giving us some jumping off points for potential avenues of criminality, which is great. But they're not giving us alternative interpretations of this, which we'll talk about in a minute. So then we get finally to the probable cause stuff. Okay, this is the meat and potatoes. This is the good parts. They just gave us a bunch of foundational stuff. Remember, oftentimes in the law, we talk about the IRAC format, IRAC, the issue, the rules, the analysis or the application of the facts to the rules, and then you get a conclusion. So we just got through a lot of the rules section. Now we're looking at the application. We want to know what is going on here and how the rules apply under the context. So finally, we get to this in paragraph 24. It says, on February 9th, 2022, the special agent in charge of NARA's office of the Inspector General sent NARA the referral via email. Okay, the National Archives head librarian says, the books are not back. I want you to go get them. Sends it over to the DOJ, which is what governs the FBI. The referral that the FBI got said that according to NARA's White House Liaison Division Director, a preliminary review of the 15 boxes indicated that they contained newspapers, magazines, printed news articles, miscellaneous printouts, presidential correspondence, personal and other post-presidential records, and, quote, a lot of classified records. Parentheses. Of the most significant concern was that highly classified records were unfoldered, intermixed with other records, or otherwise improperly or improperly identified. And this is coming over from NARA's White House Liaison Division Director. Don't know who that is. On February 18th, then, just a couple weeks later, actually 1 week later, the head librarian of the United States, the archivist, chief administrator for NARA, stated in a letter over to Congress, Chairwoman Honorable Carolyn Maloney, who I'm pretty sure just got her caboose thrown out of Congress, just lost to the waddler Jerry Nadler. They sent a letter over to her, and I'm pretty sure she's a Democrat who hates Donald Trump, so that's interesting. Says, quote, NARA had ongoing communications with representatives of former Trump throughout 2021. Which resulted in the transfer of 15 boxes to NARA back in January of this year, 2022. NARA has identified items marked as classified national security information within the boxes. What is it? I don't know. The letter also stated that because NARA identified classified information in the boxes, NARA staff has been in communication with the Department of Justice. So the head librarians, they get all very angry and they say, all right, well, you better just send this stuff over to the DOJ. We're very angry that this stuff has not been turned over. The letter was made public. And on February 18th, the same day, Trump got out and he posted on Truth Social, or he made this public statement here. He said the National Archives did not find anything. They were upset upon request that presidential records in an ordinary and routine process to ensure the preservation of my legacy and in accordance with the Presidential Records Act, so on and so forth. Right? So they're saying that Donald Trump is saying that I don't have anything left to give you and that I am not entitled to give you any of these documents, which we are going to talk about because I think he's right. And so do Democratic judges, one of them named Amy Berman, who went to Harvard and made a similar ruling in the D.C. Circuit case in Judicial Watch versus NARA. I think that was back in 2012. So it's before that. There's a lot to unpack here, but this is the Donald Trump statement. And they say, listen, Donald Trump posted this. And what that means to us is that he is not going to be cooperating with us anymore. He's not going to be turning any of this stuff over. He said there's nothing left. And so on and so on. He says, Russia, Russia, Russia hoax, and so on. Then we get to paragraph 26, and here it starts. The redaction fever begins. Paragraph 26, right? And this is right after, let's see if we can fill in the gaps a little bit. February 18th this year, Trump says, I'm not giving you any of these records back. You came by, you got what you needed. Get out of here. Paragraph 26, redacted. Paragraph 27, redacted. Paragraph 28, redacted. 29. Then we get to paragraph 30. And so the rest, and it's a new paragraph, it's a new subject. So we don't really know sort of how they ended that. But they're talking about, I would guess that these paragraphs are sort of talking about the exhaustion of the ability to work with Trump, right? In other words, they start here and they say, on February 18th this year, we said we want access to the records. Trump responded the same day, said no. This paragraph. So we said we need them, yes. And then paragraph 27, Trump said no. And then 28, we said yes. And then 29, Trump said no. And then we had to make a decision, something like that. But then we get a whole new topic. Okay, then we fast forward and they sort of go back to the beginning. And they say, okay, this is why, we needed to jump to this unprecedented, insane act. They say boxes containing the documents were transported from the White House to Mar-a-Lago. And again, as we talked about earlier, right, there's this concept in the law called chain of custody. You have to follow something from one person to another. In a DUI case, we follow the blood sample from a person's body through the needle into the vials, into the evidence locker, from the evidence locker out to the crime lab tech, or the person who pipettes the vials, shoves it in the machine, to the person who writes the numbers down and impounds it back into evidence before it comes to court. Right? That's an entire chain of custody. Following it from A to B to C to D, follow the bouncing ball. Same thing happened here. The government is trying to make this case. They're trying to say those documents left the White House and they ended up in Trump's closet. So they start at the beginning. They say, okay, well, here we are. Beginning in January of 2021 now, they say, according to a CBS Miami article titled Moving Trucks Spotted at Mar-a-Lago, published on Monday, January 18th, 2021, at least 2 moving trucks were observed at the premises on January 18th. Now, we're talking about moving trucks. And then we get major redactions. Okay, the rest of paragraph 30, paragraph 31, 32, redacted. And then we see this big box here. Now, what could that box be? I would guess it's a photograph, right? That's probably a big photo here. And so I actually went and I found that article. Let's see if we can pull it up here. There is the article that came out from the, where did this go? Yes, here it is. CBS article. They talk about this article in particular, and then there's a video. So again, we're putting ourselves in the framework of the FBI agents, and we're trying to ask ourselves, what are they doing? What are they redacting? They just got done talking about the moving trucks, and they referenced this CBS article from January 18th. It's literally the same article. They say moving trucks were spotted on Monday at President Trump's Mar-a-Lago club in Palm Beach. At least 2 trucks with boxes of items were spotted by news helicopters being wheeled inside the estate. Boxes going into the estate. Okay, so they saw them leaving the White House and then going into Mar-a-Lago. There was a large security presence around the compound, along with at least one Palm Beach County Sheriff's Office helicopter flying above. Whether President Trump can make Mar-a-Lago his permanent residence is still unclear. And that is the article referenced in the affidavit, right? And we're thinking that maybe there's a photograph there of the boxes going into the Mar-a-Lago residence. And here is the actual video from that news clip that was published back in 2021.
Today, moving trucks were spotted at Mar-a-Lago in Palm Beach. At least 2 trucks with boxes of items were being wheeled inside. There was also a large security presence at Mar-a-Lago with a USA helicopter and a sheriff's office chopper flying overhead. Whether President Trump can make Mar-a-Lago a permanent residence is still unclear. He's expected to fly to Palm Beach Wednesday, marking his last ride on Air Force One ahead of Joe Biden's inauguration. Vice President Mike Pence is expected to attend the inauguration.
Okay, so we see these boxes, right? Maybe those are the boxes. And, you know, maybe there's National Archivists or there's FBI agents or there are actually people monitoring this. You know, they're actually sort of cataloging this and watching these boxes, maybe right there. Are those classified markings on there? I don't know, but they are following the boxes moving around. Now, in the affidavit, you can see there's probably some photographs, right? We don't know what is right there in the affidavit, but it's presumably a photograph. And then we see that's probably more explanation. 34, redacted, 35, 6, 7, all redacted. And that was all part of the moving section that was talking about the moving boxes. But then we get the provision of the 15 boxes to NARA. Remember, a big group of those boxes came back, and we don't get any more details about that. And presumably what is happening here is they're talking about, okay, once we pick those boxes up, then we went through them. We rummaged through them and we found X, Y, and Z, right? This is what we found. On or about May 6th, we get a little bit of meat here. 2021, NARA made a request for the missing presidential records archives, and they continued to make requests until December 2021, when, look at this, when NARA was informed that 12 boxes were ready for retrieval at the premises. Weird. So you're telling me that on May 6th, Trump said, here, have the boxes back. 2021. They come back, boxes are ready, come and pick them up. So they go and they pick them up. Now, what are they going to say? They're going to say, we went and rummaged through these boxes and here's what we found. 37 this and 57 whatever, and here's this. Footnote number 1, we also saw this and it's a reference back to that or whatever. 40, 41, 42, 43, 44, 45, 46, all redacted. No information about it. And then another, maybe a photograph that we can't see. Nothing in there. Don't know what that is. So we see here, finally, we get down to page 17 and we get one full paragraph before we go into Redactionville. It says, and we're gonna really pause on this for a minute, but just think about how quickly we fast forwarded here. We're now in May 16 and May 18th for 2022. And before all of these redactions, what was the last date we left off on? May 6, 2021. Okay, so I want to just reference that. We fast forward basically a full year in just 3 pages, right? So we're on paragraph 39 and the time is May 6, 2021. Fast forward, we're on paragraph 47, new topic, but it's a full year later. Okay, May 18th now, 2022. They say FBI, and so I don't know what the hell happened there for that whole year. FBI agents conducted a preliminary review of the 15 boxes provided to NARA, I guess in 2022, and identified documents with classification markings in 14 of the 15 boxes. Okay. A preliminary triage of the documents with classification markings revealed the following numbers: 184 confidential or classified, 67 confidential, 92 secret, 25 top secret. Further, FBI agents observed markings reflecting the following compartments: HES, FISA, OCON, NORCON, SI. I mean, good Lord. And based on my training and experience, I know that documents classified at these levels typically, she says, typically contain NDI, National Defense Information. Several of the documents also contain to what appear to be Trump's notes, President Trump's handwritten notes, she says. which sounds like a presidential record to me, right? So 48 is, again, redacted. And we get a little bit of a snippet here that looks like it's maybe an excerpt, or I'm not sure what that might be. It's not a photograph, obviously. But 49 redacted, 50 redacted, 51 redacted. And maybe this is an email. This big paragraph, don't know what that could be. We fast forward down to paragraph 52. We're now on page 19. And it says, in the second letter, which is attached, and you say, what? What the heck where did that come from? Well, you got to remember that we were just reading through a bunch of stuff, and what they're talking about now is Donald Trump's lawyer. So presumably, these are conversations back and forth between Trump and his lawyer or legal counsel and NARA, right? It's probably an email. It's probably some sort of a conversation. And so we are actually going to take a look at that letter in a little bit more detail. But they say in the second letter that's attached here, lawyer for Trump asked the DOJ to consider, quote, a few principles, which include counsel's claim that the president has absolute authority to declassify documents. In this letter, counsel requested, among other things, that the DOJ provide this letter to any judicial officer who is asked to rule on any motion pertaining to this investigation or on any application made in connection with any request concerning this investigation. And so they're saying, hey, look, we attached counsel's letter to this motion as he asked us to do. Trump's lawyer said, if you're going to issue a warrant or something, make sure you put this letter on here so that you have our position. They also write, this is the special agent to the FBI, says, I am aware of an article published over on Breitbart. Kash Patel, who is a former top administration official for Trump, characterized as misleading reports in other news organizations that NARA had found classified materials that POTUS provided to NARA. Patel alleged in such reports that they were misleading because POTUS had declassified the materials at issue. Paragraph 54, redacted. 55, redacted. And right, this is all presumably they're responding to that claim. They're saying that Kash Patel made this statement, paragraph 54, we communicated to counsel that that's not true. 55, counsel responded and said the following, here's this paragraph. So they said something like, well, we still think it is true, and we talked to our lawyers and blah, blah, blah. And 56 says, and we responded that your lawyers are idiots and we're the National Archives and we can do whatever we want. 57, 58, 59, 60. We fast forward now several months and it's June 8th. So the letters are still going back and forth, presumably. We're filling in the gaps here. Who knows? But they say the DOJ, their lawyers, now send a letter over to counsel one for President Trump. That's his lawyer. And they reiterated that the premises, right? Reiterated, meaning they probably iterated that the first time if they reiterated it here. They say they reiterated that the premises are not authorized to store classified information, and they requested the preservation of the storage room and boxes that had been moved from the White House to the premises. They say, look, we sent you this letter, Trump. As I previously indicated to you, Mar-a-Lago does not include a secure location authorized for the storage of classified information. Right? This is a I'm angry at you email. Anytime you have to say, as I previously indicated to you, that means I think you're just a total loser. That's basically, you can just replace that with, hey, loser. Just cross that out and just type, hey, loser, right? Rather than, as I previously indicated. Hey, loser, Mar-a-Lago does not include a secure location. See, authorized for the storage of classified information. As such, it appears that since the time the classified documents so-and-so and so-and-so were removed from the secure facilities at the White House and moved to Mar-a-Lago, they have not been handled in an appropriate manner or stored in an appropriate location. Accordingly, we ask that the room at Mar-a-Lago where the documents had been stored and secured be preserved in their current condition until further notice. So it's like a preservation letter. On June 9th, lawyer responds, says, I write to acknowledge receipt of this letter. Right? I got your letter. I'm not doing any or confirming that I'm doing anything about it, but I got your letter. Paragraph 62 says something like, whatever. It says probably, and after I realized they acknowledged receipt of the letter, there were some more communications. I responded saying, will you preserve it? And they responded saying there are records or something like that. Paragraph 64, and therefore I had concerns that this might not be preserved correctly. And so I referred it over to the DOJ maybe. Paragraph 66 says there were a series of emails, maybe back and forth, speculating, filling in the gaps. So-and-so sent this over. We reviewed this document, and this document was a letter from Kim Jong-il. Nuclear codes, whatever. Paragraph 67 says, and based on all of that, we've decided in paragraph 68, the following, paragraph 69, and then therefore we get to 70. All redacted. Go! It says, there is probable cause to believe the documents containing classified NDI, National Defense Information, and presidential records remains at the premises. Why? They said, well, because our secret undercover mole at Mar-a-Lago was dancing around in Melania's closet, and they saw the nuclear codes hanging there in her shoe drawer. Paragraph 73 says Donald Trump has a manual on breaking clavicles and flying Marine One. Paragraph 75, right? The mole is still talking to the DOJ, whatever, it's all in there. So they say, all right, okay, based on all of our information here, we really know that these library books are really overdue. And based upon this investigation, I believe that the storage room, Trump's residential suite, Pine Hall, the 45 office, and other spaces within the premises are not currently authorized locations, according to me, for the storage of classified information or the NDI. Similarly, based upon this investigation, I do not believe that any spaces within the premises have been authorized for the storage of the classified information, at least since the end of Trump's term. And isn't that really nice? And furthermore, similarly, based upon this investigation, I do not believe. That's really nice. That's great. That's good. Well, you better be pretty damn sure of that, huh? Because, you're sort of opening a whole can of worms here. Don't you love that language? Similarly, I don't believe any spaces have been authorized. Holy crap. All right. 78 says, as described above, evidence of the subject offenses has been stored in multiple locations on the premises at Mar-a-Lago. Melania's closet, the powder room, the whatever. Accordingly, this affidavit seeks authorization to search the 45 office and all storage rooms and any other rooms or locations where boxes or records may be stored within the premises as described. The premises is currently, look at this, closed to club members. So I guess that sort of undermines the exigency arguments. Like, the argument is that like somebody's just going to go golfing and then walk in there and get into nuclear codes. It's closed to members. And it's got to be protected by what? The Secret Service, because Trump has Secret Service protection for life. They say if at the time of the search there are areas that are being occupied or rented or not otherwise used or available, the search would not include those areas. And therefore, writes the special agent, based on the foregoing facts, I submit that probable cause exists to believe that there are fruits of evidence of a crime here, and this affidavit supports probable cause. I also request that this puppy be sealed so that I can hide my nefariousness. I believe that sealing this document is necessary because the items yet to be seized are part of an ongoing investigation, and this might severely jeopardize the inquiry. Now, they also put together here search procedures for handling attorney-client privilege information. They say that these procedures are going to be executed by the following individuals: a case team, law enforcement personnel conducting the investigation, and law enforcement not participating in the investigation who are going to search the 45 office and be available to be a part of the privilege review team. Yeah, and I've got a lot of questions about all of this. So, we can put many of these questions into a category of sort of like procedural questions and issues. The first time that NARA got the boxes back, I would say, the 12 boxes, the 14 boxes, the 15 boxes, did they do the same thing? Or maybe Trump's people were doing some of this? I don't know. The case team will be responsible for searching the target premises. However, the privilege team is going to go into the 45 office. So a bifurcation of the teams. And they're going to separate the document and the data containing the attorney-client privileged info. They say, if the privilege review team determines the documents are not attorney-client privileged, then they're going to send the law enforcement personnel over there to mop it all up. If at any point law enforcement identify data that might be attorney-client privileged, they're going to kick it back to the other team. Okay, so there's two teams going to be going through it. One's a privileged team, one's a non-privileged team. If a non-privileged team sees potentially privileged material, they're going to just turn it over to the privilege team and they'll deal with it. Respectfully submitted by FBI Special Agent so-and-so. Oh man, we don't even get any handwriting, do we? Bummer. Signed off on by Bruce Reinhart, judge for the District of Florida, signed off August 5th. Of course, the raid took place on August 8th. Now, let's break this down here in a little bit further detail because we've got a lot of questions to unpack. When we reference the timeline on this whole thing, and we talked about the U.S. Code, we talked about probable cause, we have to make sure that we're within the hula hoop of each particular criminal provision. And when we look at these, right, something that I highlighted, I think in every one of these, is knowing or having reason to believe. Okay, it's called a mens rea. It's called the mental element of all of this. If you steal a candy bar, you sort of have you think about this just mechanically, not criminally, just mechanically, right? You have a mental thought and then you have an act. I want this, I'm going to take it and not pay for it. And I'm going to have an action whereby I take it beyond the point of sale. Two things, an action and a mental state. This is kind of like a stealing of a library book or a candy bar is what they're saying. Trump took the documents and he's also got to have a mental component to the crime. Otherwise, it's not a full crime. Criminal law, we call it mens rea and actus reus. It's two pieces like 1 + 1 = 2. Here, 18 U.S. Code 793C, knowing or having reason to believe. 18 U.S. Code 1519, destruction of records with intent to impede or to obstruct. And all of this relating to the destruction of records. And 18 U.S. Code 2071. Same thing here. I don't have this one highlighted. We're going to come back to that one later. But that is the one where you see that they can be we'll come back to that one. That's a juicy one. But those are the different elements, right? Those are the different crimes that they're talking about. And we didn't hear almost anything about Donald Trump or his internal state of mind in there, unless that was all part of what was redacted. Right. And it's his property. It is his privilege. It's his right to privacy and it's his Fourth Amendment. So when you juxtapose that with all of this, what I did in this timeline is I actually clipped out the specific paragraphs and the specific dates. And you can synthesize that entire document, the probable cause statement, into about these 7 or 8 different clips. Right. What you see right here is basically the paragraphs in between the redactions. If you strip out all the redactions, this is more or less what you see. And I would just want to point out, right, we have May to December. We've got records being returned. On May 6th, NARA made a request for the missing records. NARA got 12 boxes and returned them. We fast forward May 16th through 18. They do a preliminary review. They identify there are some confidential documents in there. There's letters back and forth now. May 25th, and counsel sends a letter back. Right? This is Donald Trump's defense team. And they're making the following arguments. They say as follows. Trump's defense lawyer writes on May 25th, 2022, not long ago. He's sending this letter over to Jay Bratt, Counterintelligence and Export Control. He says, I write on behalf of Donald Trump about this ongoing above reference matter, the presidential records investigation. Right? This is Trump's team making defense arguments. He says, listen, U.S. DOJ, public trust in the government is low. At such time, adherence to the rules and longstanding policies is essential. Trump is a leader of the Republican Party. The DOJ is part of the executive branch, is under the control of a president from the opposite party. It is critical, given that dynamic, that every effort is made to assure that the actions by the DOJ that may touch upon the former president and his associates do not involve politics. There have been public reports about an investigation by the DOJ into presidential records, purportedly marked, according to you, as classified, among materials that were once in the White House and unknowingly included among the boxes brought to Mar-a-Lago by the movers. It is important to emphasize that when a request was made for the documents by NARA, Trump readily and voluntarily agreed to their transfer to NARA. The communications regarding the transfer of the boxes to NARA were friendly, open, and straightforward. Trump voluntarily ordered the boxes to be provided to NARA. No legal objection was asserted about the transfer. No concerns were raised about the contents of the boxes. It was voluntary and open. Unfortunately, writes Trump's lawyer, the good faith demonstrated by Trump was not matched once the boxes arrived at NARA. Leaks followed, and once the DOJ got involved, the leaks continued. It's almost as if Trump should have never given any boxes back, because once they got them, it opened the door and they said, oh, you've got all these classified documents, which gives us the pretext to go and raid your house. Leaks about any investigation are concerning, writes the defense. But leaks about an investigation that involved the residence of a former president who is still active and on the national political scene are particularly troubling. This was back in May. Counsel writes, it's important to note a few bedrock principles here. First, number one, DOJ. A president has absolute authority to declassify documents. Under the U.S. Constitution, the president is vested with the highest level of authority when it comes to the classification and declassification of documents. Look at U.S. Constitution Article 2, Section 2. Quote, the president is the commander-in-chief of the Army and the Navy of the United States. His constitutionally based authority regarding the classification and declassification documents is unfettered. If you'd like to know more, take a look at Navy versus Egan, U.S. Supreme Court, 1988. That case said, quote, the president's authority to classify and control access to information bearing on national security flows primarily from this constitutional investment of power in the president and exists quite apart from any explicit congressional grant. Do you see what that says? It's saying that the classification authority comes from the Constitution, not from Congress, not from the National Archives, not from NARA or from some FBI bureaucrat who says, that's classified. It has to go in a box and put a lid on it. No, it's the president. He gets to decide. Why? It's constitutional. It's not legislative. Number two, presidential actions involving classified documents are not subject to criminal sanction. Any attempt to impose criminal liability on a president or former president that involves his actions with respect to documents marked classified would implicate grave constitutional separation of powers issues. Beyond that, the primary criminal statute that governs the unauthorized removal and retention of classified documents or material does not even apply to the president. That statute in pertinent part is as follows. Take a look at 18 U.S. Code 1924A. It says as follows. Whoever, being an officer, employee, or contractor, or consultant of the United States. Did you see the word president in there? Let's read that again a little bit more slowly to see if we can see the word president in there. It says, It says, whoever, being an officer, no. An employee, no. No, employee, no. You're kind of employee if you work for the president, not if you're the president. You're kind of the boss if you're the president. Contractor, no. Consultant, no. By virtue of his office, employment, position, or contract becomes possessed of documents or knowingly removes them can face criminal liability. They say here under U.S. Code, it says, an element of this offense, which the government must prove beyond a reasonable doubt, is that the accused is an officer, an employee, a contractor, or a consultant. The president is none of those things. How do you know that? Well, it says Article 2 of the U.S. Constitution, Section 2, Clause 2. And it comes from a case, a 2010 case, talking about officers of the United States. Saying here, an officer of the United States can only be appointed by the president. So the president doesn't appoint himself. By and with the advice and consent of a Senate. A person who does not derive his position from one of these sources is not an officer of the United States. Thus, the statute does not apply to acts by the president. Number three, the DOJ, you people must be insulated from political influence. According to the Inspector General of the DOJ, one of the top challenges facing the department is the public perception that the DOJ is influenced by politics. True. The report found that one important strategy that can build public trust in the DOJ is to ensure adherence to policies and procedures that protect the DOJ from political accusations. And so we request that the DOJ adhere to the longstanding policies and procedures about communications between the DOJ to prevent political influence from crossing over. That didn't work out too well, did it? And number four, it says the DOJ must be candid with judges and present exculpatory evidence. must present exculpatory evidence. We're going to come back to that. Long-standing DOJ policy requires that DOJ attorneys be candid in representations made to judges. You can't just make stuff up. Pursuant to those policies, we request that DOJ provide this letter to any judicial officer who was asked to rule on a motion pertaining to this investigation. And they did. They included it. Or on any application made in connection with this request. The official policy of the DOJ further requires prosecutors to present exculpatory evidence to a grand jury. Pursuant to that policy, this was not a grand jury, this was just a judge. Pursuant to that policy, we also request you give this letter to any grand jurors or any grand jurors asking for subpoenas. With best regards, M. Evan Corcoran. Signed off on, copied over to Matthew Olson. We've talked a lot about him previously. So we're going to take a look at that, exculpatory evidence. And we're also going to briefly review this concept on particularity. Because remember, Attachment A tells us more about the premises to be searched. It describes a mansion with 58 bedrooms, 33 bathrooms, and 17 acres. Includes things like 45 office, quote, all storage rooms, and quote, all other rooms or areas within the premises that are available to be used by the president and his staff in which boxes or documents could be stored, including, look at this, all structures or buildings. Does not include areas at the time of the search being occupied or rented by third parties or private suites. Property to be seized. Any physical documents with classification markings, any evidence of the knowing alteration, and we had a lot more there, any government or presidential records created between January 20th, 2017 and January 2021. Do you see the scope, the breadth of this request? That's the entire affidavit that was unsealed from the raid on Trump's residence at Mar-a-Lago. And we've gone through it in good detail. Now let's raise some questions. You can see that's basically the entirety of the document of the probable cause portion laid out right there for us. But we have some very, I think, important questions to ask, in particular about what is missing. What does the affidavit, although highly redacted, seem to be lacking? Well, we've got a couple things we can talk about. First, defense arguments of failing to provide exculpatory evidence. Remember that we've got a lot of evidence about intent that we need to prove if the government is to be successful in this case. 18 U.S. Code says intent about willfully or unlawfully doing these things. Intentions to impede or to instruct. Or 18 U.S. Code 793, having reason to believe at the time that it's been improperly taken, right? Mens rea mental states. Haven't seen any of that. In fact, we've got some pretty hard evidence that Trump said the opposite of that. And so my first question is, was that included as exculpatory information? We got a lot of the affidavit that was highly redacted, but did they say anything about Trump walking into that meeting and saying, anything that you need, you got it? Was that included? I don't know. Seems like maybe they're missing some of the intent elements. They might also be talking or missing portions about the presidential privilege argument that has been waived and battled. Don't know. It was in there, or it has been a topic of conversation, but we don't know if it was in the redacted portions of this. Did they talk about privilege outside of the teams that were going to be sorting through the materials? We don't know. All redacted. They talked a little bit about the declassification, but we only saw that essentially in the letter that was attached by Corcoran. They didn't respond to that in the affidavit, right? They didn't respond, at least in what we saw. They didn't say, this is why Trump did not classify those things. This is why these documents are not privileged. They presumed that they were all classified, and they didn't present any exculpatory evidence to make the case that would put Trump in a light most favorable to him. The U.S. government obviously secured the facility. Secret Service was all over the place. They were talking about low security and making it seem as though nothing was secure. They didn't tell us anything about privacy right holders, right? Trump, as the owner of the property, presumably, has the privacy privilege, and he's protected by the Fourth Amendment. And so they didn't really get any particular details about Trump or any of his statements. And so we can't see much of really anything that came out of this. And I've got a lot of open questions. These are all areas that I would jump off on in questioning the case. Now, the big one that really stands out is this exculpatory information from this companion case. This is the Clinton sock drawer case. Judge Amy Berman issued a ruling in this case. Remember that Clinton retained documents in the form of audio recordings after he left the Oval Office. And when he was sued by Judicial Watch, when they sued NARA, the judge came out and said the following: would there not be a high level of deference accorded to the president's decision about which records are personal? In other words, can't the president make the decision about what records are to be retained and what are personal presidential records? She says yes. She also said the court has serious doubts about whether the former president's retention of the audio tapes as a personal matter is even subject to judicial review in the first place, right? How can a Florida District Court magistrate judge make a decision that overrides and usurps Trump's decision on presidential records if his decision also usurps NARA's, according to Amy Berman? It's not possible. It's ridiculous. Similarly, I want to talk before we get to the reaction. I know I'm going long on this, but there's just so much to say. The particularity conversation is just as problematic. In the affidavit, we saw them explain what they wanted to search with a gigantic scope. Here's what they said. Any government or presidential records created between January 20th, 2017 and January 20th, 2021, they want access to. Well, there's a problem with this. In the United States, we have something called particularity, and it's very important. It's very relevant to the Fourth Amendment. And I want to share this law review journal with you. Let me cue this up so that I can open it up with our red pen here, and we can really get into some details on this. But this is just a short article. I'm not going to read the whole thing. There's a reason why I like to look at law review articles, because law review articles give us a nice sort of quick summation about how some of the mechanics work on Fourth Amendment law. They just sort of detail this for us relatively quickly. And so particularity, when it comes to the Fourth Amendment, can be explained pretty simple. It says here, this is a law review article. It says, wrong but reasonable. The Fourth Amendment particularity requirement after United States versus Leon. Here's a quick explanation of how this all works. It says the Fourth Amendment to the United States Constitution requires that warrants describe with particularity, specifics, the places to be searched and the things to be seized. Footnote 1. Where does that come from? Here it is specifically. Fourth Amendment, it says, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Writes, the insertion of this clause into the Constitution came out of the Revolutionary War. They were very angry and had a lot of antipathy toward highly intrusive general searches. The particularity clause guaranteed that government agents could no longer rely on indiscriminate or overbroad warrants to engage in general, exploratory, or rummaging in a person's belongings, which is exactly what they did with that request here. Any government or presidential records over the last 4 years. Zero particularity. It's a general, broad search, extremely, I'd say, outside the scope of anything that's reasonable. And the affidavit doesn't change that argument. So the Trump warrant affidavit is completely unsealed at this moment. We have a lot of questions. I've got a lot of issues with their claim that this was all legitimate and justified. But the downside that we have is we can't see what's in the full affidavit. And at this point, it's probably not anything that we're going to see until this case develops a little bit more. And if and when they decide to charge him, only then will it very likely be released in full.